So good morning, everybody. Welcome to today's session of Impact of COVID-19 and the CARES Act on your retirement plan. Well, first of all, we want to thank everybody for joining us for the next hour and taking time out of your day to hear about all the implications for plan sponsors on your benefit plans. Hopefully, we get you some good information that you'll be able to use to manage your plan and help out with all the changes that are happening. So a couple housekeeping items. The session is being recorded, so don't worry if you missed something, you'll be able to go back. We will email out a link to all attendees of the session after the session. So it'll provide a link where you'll be able to download the webinar along with the slides, or else you can access it at our website at www.mjcpa.com. We'd love to hear from you. If you have any questions throughout the webinar, there's a Q&A box at the bottom where you can type in your questions. We do have close to 300 or plus attendees this morning, so if we don't get to your question, please don't hesitate to email any of the panelists with your questions after the webinar, and our contacts will be listed at the end of the presentation, so you'll have all that information. So to introduce our speakers, again, I'm Diane Kopczynski. I am a partner with Malden & Jenkins CPA and Advisors. I have been auditing and consulting for over 25 years, and I have employee benefit plans has been a significant part of that. We have Christian Bennett, who is also with Malden & Jenkins. He's a partner in our Chattanooga office, and he as well has a concentration in auditing employee benefit plans with over 20 years of experience as well. Next, we have Doug Dahl with the law office of Berry, Bass, and Sims. And Doug draws on his experience as an attorney with the IRS. He was with the Office of Chief Counsel for over 10 years, and he's been providing technical knowledge and advice on ERISA matters and employee benefit issues. Next, we have Brad Gayhart, is the Managing Director at Sarasota Private Trust Company. He has over 20 years experience with wealth management, working with clients on investment strategies and employee benefit plans. And lastly, Brian Vollner is a managing director with Sarasota Private Trust Company. He's kind of in the background, but he also has 20 years of financial services experience as well. So just quickly to go over the agenda, and then we'll jump into it. So first, we're just going to start off just with some plan considerations that you need to know with all the changes, everything that's been happening, just some important plan considerations that you need to have. Next, we'll touch slightly on the CARES background because it is 892 pages, and I'm sure everybody has read it so far. So we'll touch on that slightly. And then we'll dive into the major provisions really of that act related to retirement plans for participant relief, distributions, loans, and such. And then we will get into some plan sponsor relief that's sitting out there. And this is mainly related to funding and some IRS deadlines that are out there for you plan sponsors. And then we'll just touch on some additional guidance and relief for retirement plans throughout, and we'll end with that. So let's dive into it, and I will now turn it over to Brad to get us started.
Okay, thanks, Diane. The first topic of discussion today will be furloughed employees versus laid off employees. This is a question we all seem to be getting on a regular basis. As per a furloughed employee, that's an employee placed on employer-mandated leave of absence without pay. Furloughed employee is available for work, but not actively working and is not being paid. Whereas a laid-off employee has been terminated, the employee-employee relationship has actually ended, and unless rehired, there's no possibility of returning to work. These are obviously important because we'll go back to this throughout our discussion today. Finally, whether an employee has been furloughed or laid off determines whether certain benefit options are available. I know that we have had a couple of questions that come in prior to our webinar today. Diane, if you'd like to kind of address those to the group.
Yeah, a couple questions that we've got. One is, as far as layoffs and furlough, if they are a result of COVID-19, taking into account for partial plan termination, and if so, how long does a layoff of more than 20% of employees have to last before it becomes a partial plan termination?
Okay, that's great. Hey, Doug, would you like to go ahead and kind of answer that?
Sure. Yeah, and I'm happy to. The determination of whether there's been a partial plan termination is based on a certain number of participating employees who sever from service during an applicable period. Generally, it's a 12-month period, but the key there is that for a partial plan termination to be triggered, there actually has to be a severance from employment. And that's why this distinction between a furloughed employee and a laid off employee is important here and important in a number of other areas. A furloughed employee does not have a severance from employment, so shouldn't be taken into account in a partial plan termination. Whereas someone that's been laid off, even if there's an intention to rehire, a laid off person still is individual has been severed. So there is a severance from service during that period that those individuals would count towards the 20% threshold to determine whether a partial plan termination occurred. Now, I will say that the determination of whether a partial plan termination occurred is highly fact specific. It's a facts and circumstances test that the IRS looks at. We haven't seen yet any, and I know one of the questions may be whether there's any relief in this area. If an employer has had a layoff because of COVID-19 or because of mandatory full or partial shutdowns, whether the IRS will provide any relief. We haven't heard anything on that yet. It's possible that there would be relief, and the relief might say that if there were layoffs or termination directly resulting from COVID-19, they won't go into the calculation of partial plan termination. But I have not seen anything like that yet, and so I don't know for certainty whether something like that will be whether relief will be offered.
Okay,
that's
thanks.
great.
Yeah, I think you covered the other two questions out there too. So.
Okay, excellent. So moving forward, Doug, I know a lot of folks are asking questions about plan contributions moving forward. So I'll let you kind of address this section.
Sure. Really about a week, just a week into the COVID-19 crisis, we started to get questions from clients about, that we're having cash flow and other issues that they we're either having currently or anticipated on the horizon. So one of the first questions that clients asked us were, how can we stop contributions or suspend contributions to our 401k plan? I think at that point, and still today, but really in those first couple weeks and first month, clients were looking at all avenues to try to conserve cash and basically trying to figure out options, to withstand the crisis. And that was one of the first questions. Can we stop or suspend contributions to our 401k plan? And the initial question that we had for them and that we had to look at was, is your plan a safe harbor plan or not? If there's a safe harbor plan, then it requires some level of contribution, whether matching contributions or non-elective contributions by the employer. If it wasn't a safe harbor plan, then you may have discretionary or fixed contributions that need to deal with. And the options that were available to a plan sponsor and the ways in which you had to suspend or freeze depend on whether you were a safe harbor plan or not. So if you could go to the next slide. Yep. Yeah. Again, like I said, the determinative question is the 401k plan a safe harbor plan? If it's not a safe harbor plan, then employer contributions can generally be reduced or eliminated going forward. And there, it's important to look in your adoption agreement or your other plan document whether employer contributions were purely discretionary, right? For employers on a prototype plan or a volume submitter plan, did you check the box for discretionary contributions? In which case, those contributions could generally be suspended and not made, either suspended or terminated, right? If a plan sponsor had checked the box for fixed contributions, and let me back up to the discretionary contributions. So if you had a discretionary contributions for 2020 and haven't made any, then generally you are not required to make any contributions in 2020 at all. So no action was necessary in order to suspend or eliminate. If you had checked the box for fixed contributions, or your plan otherwise provides for fixed contributions, that's where you really have to be careful, because most likely, if you had a fixed contribution in your plan, the plan sponsor will be required to make that fixed contribution up to the point in which you suspend or terminate. So whereas discretionary can be really retroactive because you're not required to make any contribution, if you had a fixed contribution, you're required to make it. So that's when fixed contributions can only be ended or eliminated prospectively. And then kind of get to that bullet about formal requirements. Again, if it's discretionary, then you may not need to do anything to your plan, and really don't need to if you would check the box for discretionary. But if it's a fixed contribution, then plan sponsors definitely need to go in, amend their plans to either uncheck the box for fixed contributions completely, or uncheck the box and then just check the discretionary box. So if a client is thinking, we can't make our fixed contribution, or we don't know whether we're going to be able to make it, but we do want the flexibility to offer discretionary contributions later in the year if our financial situation turns around, then you can uncheck the box for fixed contributions and indicate that you may want to make discretionary contributions. I know, turning to Christian or Diane, I know there's some audit considerations to think about here.
Yes, thank you, Doug. Consistent with comments I'll make throughout the presentation, leave it to auditors to want to have documentation, and that doesn't that's not inconsistent with what Doug has spoke about here. So in regards to employer contributions, first and foremost, your plan document guides your plan. That's what you have to follow. So the first thing you need to do before you make a decision is look at what your plan document says, review it, understand it, talk with your TPA, your ERISA counsel as necessary. If you do elect to make changes, I would highly suggest and recommend that any changes to the plan document be approved by your formal committee, whether that's a planning committee, board of directors, the executive of the company, whoever is in charge of operating the plan. I would have that approved. I would have it documented in those minutes, and then of course have your amendment approved and signed appropriately. At the end of the day, from the audit perspective, when you start making changes to the plan, it's important that there's a documented trail to show that was what considerations were given and that the plan was actually approved to be changed. Doug?
I have go ahead. You want to do that next, and then I have a couple questions.
Sure. So we talked about instances in which your plan is not a safe harbor plan, but now we'll talk about if your plan is a safe harbor plan, how can you reduce or eliminate employer contributions? If the plan is a safe harbor plan, employer contributions can be reduced or eliminated only in two situations. First, if the plan's annual safe harbor notice, which is generally sent out at least 60 days prior to the beginning of the plan year, if that notice stated in it that employer contributions could be reduced or suspended during the plan year. Most of our clients and the record keepers that they were using had annual safe harbor notices that included that language. So really, you need to take a look at your safe harbor notice to see whether that language is in there. If not, then you really have to rely on this second situation. That is, if the company is operating at an economic loss for the plan year, then in that case, you can also suspend or reduce your safe harbor contributions. Now, the IRS in either in the code or regulations or any other guidance hasn't said what that means, what it means to be operating at an economic loss. So there is some gray area there. I'm not sure if analysts have any thoughts on what that means, but I think that if the employer is unable to make a required loan payment on a credit facility, or if you're able to show kind of at a snapshot point that you are operating at economic loss, that your expenses exceed your income, then you may be able to rely on that second prong and be able to reduce or suspend your match. Now, in order to reduce and suspend match, in addition to meeting one of those two criteria, you also have to give employees at least 30 days notice before employer contributions are stopped. Meaning, if you want to stop contributions on June 1, you have to make sure that employees have a supplemental safe harbor notice at least 30 days prior to that date. Your record keepers or your plan counsel can help you prepare that supplemental safe harbor notice, but it's fairly simple. It just says that the plan is suspending or eliminating, suspending safe harbor contributions on this date. And the last bullet, one of the effects of suspending or eliminating safe harbor during a year is that you lose the safe harbor status of the plan. So the plan then becomes subject to non-discrimination testing for the entire plan year. Some clients had asked whether there's some sort of bifurcation, and up until the point that you suspend or reduce safe harbor contributions, you're a safe harbor plan and don't have to test. But the IRS rules make it pretty clear that if you suspend mid-year, then you become subject to non-discrimination testing for the whole plan year.
And I think on that, as you were saying, Doug, on that second bullet, if the company is operating at an economic loss, I don't think I've seen anything out there as far as any specific standards and what they're considering an economic loss for that plan year. But hopefully a little more guidance may come out on that. I do have a question that came in as far as utilizing the true-up match. So if the plan sponsor terminates a match and he utilizes the match true-up provision, so if they don't make a match or they freeze their match, will they have to do it at the end of the year because of the true-up feature?
Yeah, there's two situations when true-ups come into play. One, true-ups are required in certain instances where you have, and this is sort of getting a little technical, but if you have an annual computation period, but you actually make matching contributions on a payroll by payroll basis, you're actually required by have elected in their adoption agreements have opted to do a true-up. And in either of those situations, if you suspend matching mid-year, at least from my perspective, and I think you have to make the true-up because the plan either you're required to by the code or you're required to because you've elected to do true-ups in your plan document. But I think that you need to if a client suspended it as of June 1, I think you'd have to look from that period between January 1 and June 1 and figure out whether a true-up would be required. And I think a true-up was would have otherwise been required, and I think you have to make the true-up.
Okay, so if they want to save match dollars, do they have to amend the plan, or is that even an option?
If you want to, I think that true-up could be eliminated prospectively if you wanted to, if it's not legally required, if it fell into that camp of being optional, it may be possible to amend it prospectively to eliminate the true-up. But that's a real, I haven't looked at that question yet, so I think you need to. You certainly can't amend it retroactively to eliminate the true-up.
Okay, and then another question that came in real quick is, do all the comments related to safe harbor apply to a 403B as well as a 401k?
Good question. I don't have a lot of 403B plans, and I'm not sure in terms of safe harbor whether those things apply. I will say that our comments regarding non-safe harbor plans for employer contributions that are non-safe harbor, those same considerations would apply to a 403B plan. I'm not sure if anyone else on the panel has any other thoughts specifically on 403Bs and safe harbor.
Yeah, I'm not 100% sure on that either as well. So, at the end of the webinar, we are going to address some of these questions outside of the webinar. So we'll be able to send you a Q&A, so we'll get an answer to that. Okay, that's all. That's it now.
Okay. So moving forward, there's some proposed relief, waive required employer contributions. This is from the American Retirement Council. Again, there's several groups out there, and not all of them have really made any movement yet. But basically, the proposed relief would include waivers for both non-safe harbor plans and safe harbor plans. But again, I really have to note here that this has not yet been written into any coronavirus related legislation and included in the guidance published by the Department of Labor or IRS. So again, there's several groups out there, and not everyone has come to a consensus yet. The ARA proposal includes the following relief for all defined contribution plans, allowing sponsors to waive required employer contributions for 2020, allowing sponsors with fewer than 500 participants to waive required contributions from 2019 that have not yet been funded. And then the plan would be exempt from making any required top-heavy minimum contributions. Moving forward, the proposal also includes on safe harbor defined contribution plans, permitting sponsors to discontinue safe harbor contributions effectively immediately. This would waive the normally required 30-day notice to employees. Instead, this would require notification to employees within 90 days of the discontinuance. An amendment would have to be adopted by the last day of the plan year. In addition, plans would remain exempt from top-heavy minimum contribution requirements. Highly compensated employees would be prohibited from making salary deferral contributions from the remainder of the year. So again, these are proposals from ARA. And nothing's set in stone yet or written into legislation, but they are talking points. In addition, we have some other things that deal with the health and welfare considerations in plans. Doug, why don't you go ahead and address this and kind of throw a little more depth into this conversation?
Sure. Yeah, and we know that the focus of this webinar is on retirement plans, but we did want to, because we touched on the furloughed and laid off employee, and because so many clients and so many of you probably have had questions or you're considering options with respect to your health and welfare plans, we wanted to include a slide on this. And really the purpose of this slide is, you see the bullet points there, but many clients have been asking whether they can continue health and welfare coverage for employees that have either been laid off or furloughed. And many of our clients initially asked about furloughed employees. And the answer is generally yes. But the most important thing is to check if you have insured, for your fully insured health and welfare plans, that you check with your insurer to see whether they agree to extend coverage to employees that are not going to meet the minimum hour requirement to continue coverage, and that may not meet an actively at work requirement for certain of the insured coverages. So in our experience, the insurers have been, and starting in March, we're agreeing to allow plan sponsors to continue coverage for these people. But that's something that you need to check with your insurers about. For a self-funded, any of you out there with self-funded medical plans or other health and welfare plans, our recommendation is to check with the stop-loss insurer to confirm whether the stop-loss insurer will extend coverage to individuals that otherwise would not remain eligible for the plan because of their either reduced hours or because they're no longer working. So that is what we wanted to just briefly touch on the health and welfare plan considerations. And Diane, I don't know if we have any questions related to health and welfare things.
Nothing's come up yet in the queue.
Okay. Okay.
Okay. So the next area is really the premise of this conversation, and it talks about the CARES Act and the background. Coronavirus Aid, Relief, and Economic Security Act. The CARES Act is a $2.2 trillion stimulus bill to help the economy recover, obviously. It was signed in by President Trump on Friday, March 27th, 2020. And the CARES Act includes provisions providing relief for retirement plan sponsors and participants. Some of the major CARES Act provisions for retirement plans: plan participant relief, coronavirus-related distributions, loan relief for affected participants, waiver of RMDs for 2020, plan sponsor relief, defined benefit plan funding relief, IRS tax filing and payment deadline extensions, CARES Act plan amendment deadline, the last day for the plan year beginning 2022. We'll hit on the highlights now, and then we'll go into a little bit more depth on all of these things. Doug, I really just want to hand it over to you here and kind of let you dive into these slides over the next few. These are questions that I know you're getting, you and both Christian, on a regular basis. So you're probably best poised to answer these. So I'll let you start.
Sure. The first slide, we talk about who is eligible for both the coronavirus-related distributions and the special coronavirus loans. In order to be eligible for either of those, a participant has to meet the definition of a qualified individual. As you see on the slide, a qualified individual is anyone who is diagnosed with COVID-19, whose spouse or dependent is diagnosed with COVID-19, or the third one, and that's a very important one, who experiences adverse financial consequences as a result of being quarantined, furloughed, laid off, having work hours reduced, being unable to work due to lack of childcare, closing or reducing hours of a business owned or operated by the individual due to COVID-19, or kind of the catch-all other factors as determined by the Treasury Secretary. On that fourth bullet, I'll note that other factors have not been determined yet by the IRS. It's certainly possible that there will be either, sometime this year or even, in next year, that the IRS comes out and says, adopt some other catch-all that allows people that took distributions or took loans to satisfy the rules. On that third bullet, we've gotten a lot of questions from plan sponsors saying, how do we make this determination, right? This is a very fact-specific determination. It also, what is quarantine, furlough, laid off, having work hours? Basically, how do we know whether certain participants have been, have experienced adverse financial consequences as a result of any of these things? And the important thing that we've told clients is it's not the client's responsibility, it's not the plan fiduciary's responsibility to determine whether one of these four criteria are met. The CARES Act makes it very clear that a plan sponsor can rely on a participant's certification that he or she is a qualifying individual. So I think because the third bullet is so expansive and there's opportunity and room for probably disagreement or debate on whether a certain participant falls within this category or not, we've cautioned and advised clients to not make that determination because they're not required to make the determination. If a plan sponsor or a plan fiduciary kind of steps in and wants to make determinations as to whether someone meets these requirements, you then kind of take on a fiduciary responsibility of interpreting the plan, administering the plan, when otherwise you can simply rely on a participant certification. Now, that being said, I think it's important for plan sponsors to and work with their record keepers on communications regarding these items to let participants know that if you don't meet one of these criteria and you do take a distribution or a loan, it's possible that you won't be entitled to the favorable treatment of these things. So it's sort of I think those considerations need to be thought through. So I'll first talk about the coronavirus-related distributions, and I think Brad will cover the coronavirus loans. if for participants that meet the definition of qualified individual, they can take a special coronavirus-related distribution of up to $100,000. Now, they can take this from any or all of their retirement plan accounts, meaning if you have one 401k plan with a prior employer and a current employer with a 401k plan, you could potentially take up to $100,000 total across all of the plans. And so you couldn't take $100,000 from one and $100,000 from other. The amount is aggregated across all your eligible plan accounts, assuming that those plans are going to allow this. The CARES Act also doesn't provide a limit to the number of distributions that can be taken, as long as they're all taken by December 31 of this year. That means that a plan could allow several distributions of $10,000, $200,000, $20,000 until you reach that $100,000 mark. Now, I think a lot of plans don't want people to kind of come back to the pot, 20 times in little increments. So I think we hit on it on a later slide that some record keepers are establishing rules related to coronavirus-related distributions and plan loans that may be a little bit more restrictive than what the CARES Act allows. So although the CARES Act doesn't limit the number of distributions that can be taken, it's possible that the record keeper that you work with will limit it for administrative reasons. That last bullet is that former employees who still have a balance in the plan are eligible or potentially eligible to take a coronavirus-related distribution, assuming that your former plan allows for that. So what plans are eligible to allow the coronavirus-related distributions? All 401A qualified plans, 401Ks, 403Bs, 457Bs, and IRAs are eligible to allow these distributions. That second bullet highlights that a plan is not required to allow them. The CARES Act provisions were permissive with respect to these items. So plan sponsors have the ability to decide whether they do want to offer coronavirus-related distributions or not. Again, I mentioned it earlier, when can coronavirus distributions be made? They're allowed anytime between January 1, 2020 and the end of this year. This first bullet indicates the income tax, and one of the reasons that coronavirus-related distributions may be advantageous for plan participants over participant loans, and that is participants can elect to pay any income tax on the coronavirus-related distribution over a period of 3 years. So if someone takes the full $100,000 in 2020, they don't have to pay tax on that, a full tax on that amount in 2020. They can spread it equally over 3 years. When those coronavirus distributions are made, they're not subject to early withdrawal penalties or withholding. The general 10% early withdrawal penalty that would apply if you took a distribution prior to age 59 and a half doesn't apply. It's not eligible for a rollover, and so the 20% mandatory withholding doesn't apply. This coronavirus-related distribution is a special new type of distribution. It doesn't have to meet the plan's existing hardship withdrawal rules or other rules regarding in-service distributions. If the participant is a qualified employee, that is all that is necessary to allow for the distribution. Another reason why the coronavirus-related distribution may be more advantageous than a plan loan is that distributions can actually be repaid in full or in part over a 3-year period. And that 3-year period starts ticking the day after the distribution is received. So these coronavirus-related distributions can really be, in a way, used as a loan because as long as they're repaid, by the end of three years, then they can really be treated as a loan. The repayments can be made in a single amount or in multiple payments. At least that's what the CARES Act allows. Again, record keepers may adopt different procedures regarding repayments. Repayments are not adjusted for investment earnings. If an individual makes a repayment after 2020, they can later amend their 2020 tax return to recoup taxes paid. And that would also apply for 2021 and 2022. So if a participant receives $100,000 in 2020 and repays it by the end of 2020, then there's no tax that had been paid. So there's no need to amend a tax return. But if a participant makes a repayment after 2020 or after they file their taxes in 2020, or they do it in 2021 or 2022, then a participant can go in, amend their tax return, and get back any taxes that were paid. This next bullet is kind of an interesting one. The CARES Act provides that the repayment can be made to an IRA or to another employer-sponsored plan that accepts rollovers. This means that if you take a distribution from your 401k, then as long as the IRA provider allows, you'd be able to roll that amount over or repay it into an IRA. Not exactly sure why a participant would want to do that. You'd think that they would want to repay it to the plan that they took it out of, but that availability is there. Christian or Diane, are there any audit considerations here?
Thanks, Doug. There are and this is more from a compliance perspective, but things that we as auditors consider when we audit your plan. First of all, again, it's document in your minutes the approval of these types of distributions, because they're not automatic. The plan has to allow for it. And you could have a basic plan document from your TPA that the TPA adopted these amendments, but you as a plan itself has no record of it. That could be problematic at some point. So document whether you're going to allow these or not. It's your call, your determination. And then these next three comments, I don't think will be a big issue, because all this is primarily going to be performed by your TPA and not by the plan itself. But you do want to make sure that there are procedures in place to ensure that participants are only getting $100,000 or up to $100,000 across the board, that they don't exceed that amount. You also want to ensure that there are procedures in place that capture repayments are treated as rollovers, as Doug just mentioned, and not as amounts dispersed, that the amounts paid back in are rollovers and are limited to the amounts that were dispersed. So say that a different way, if a participant takes a $50,000 coronavirus distribution, you want to make sure that the repayment back in as a rollover is only $50,000 and not $60,000. That would not be allowed. And then we also want to make sure that the plan, you have to remember that the plan has the ultimate responsibility, again, to operate the plan in compliance with the plan document. So as I said, the TPA primarily will be handling all these distributions and the recouping of funds if the participants repay them. But the plan at the end of the day has the ultimate responsibility.
One question that we did have come in is, do hardship distribution withdrawals change at all? And I believe with this act, nothing has changed as far as hardship distributions related to anything so far, with anything that's come out yet so far.
Sorry, Danny, can you repeat that question?
It said, do hardship distributions change at all? And I do not believe they change at all. Any of the hardship distributions, I believe the rules are all still the same related to those. So, Doug, do you have any, as far as any fiduciary concerns or considerations that plan sponsors should be thinking about?
Sure. Yeah, I mean, this kind of is just a general question. One thing that we have been, I think it's important during this time to kind of heighten your fiduciary compliance, meaning I think it's important for fiduciary committees, retirement plan committees to be meeting, at least quarterly, and to be able to show the DOL during an audit that you were meeting and that you were, fulfilling fiduciary duties. Important to hold those meetings and to record them, using minutes. So to document that those meetings occurred and what was discussed at those meetings using minutes. I think it's really more important than ever during this time because of the fluctuation in the market and because of all the changes that are being made to the way retirement plans are administered and some of these special rules that we're talking about. I really do feel like it's an important time to kind of ramp up fiduciary compliance. One question we've gotten, we have a number of clients who have company stock as an investment option in their 401k. I think it's particularly important in this time, given the way the market has operated and will likely continue to fluctuate. I think it's really important to have regular quarterly meetings and discuss the company stock fund investment. I'm not saying that drastic actions need to be taken, like you need to freeze or eliminate, but I think fiduciary committees should discuss the company stock fund investment, the prudence of continuing the company stock fund investment, and they should document in minutes that they've discussed it. I think it's very important because in 08 and 09, there were a bunch of stock drop cases, and there's likely to be litigation in the coming years following the COVID-19 crisis related to specifically to company stock in both 401k plans and ESOPs. So I think it's important to think about that.
Yeah, and like you said, plan sponsors need to make sure that they're documenting these in minutes. You may not be having you should be having formal meetings at least every year, quarterly, hopefully, but definitely have everything documented in the minutes so that you have documentation and support for the decisions that you're making with all of this.
No, excellent. And just to move on, I know we're getting a little short on time here, so I'll go through loans fairly quickly, but I will draw you in, Doug, a couple times here just to get your opinion on things. So the CARES Act offers two coronavirus-related loan provisions. First, loan limit for qualifying individuals have been increased. Second, qualifying individuals are granted a 1-year delay in repaying their loans. Coronavirus participant loan relief is only offered if the employer elects to include these provisions. And then the plan must include a loan provision for the relief to apply, or at the very least, a participant loan policy should be in place. So to drill down a little bit, the increased loan amounts for qualifying individuals, participating loan limit has been increased 100% of the participant's vested account balance up to a maximum of $100,000. The participant loan limits are normally 50% of the participant vested account balance up to a maximum of $50,000. And the increased loan amount only applies to loans made on or before 2019, I believe. I'm sorry, 2020. Sorry, my slide's cut off. Doug, have you been getting any questions on these loans from plan sponsors?
Yeah, and we may cover it in a later slide, but I think most plan sponsors are adopting all of these provisions that we're talking about. In fact, record keepers, and again, we may get to it in another slide, but record keepers, a lot of them are basically just going to amend the plans as a default unless employers opt out. And so because of that structure and for other reasons, I think most plans will be adopting all of them. But we have had some clients that either don't allow loans currently or don't really think that these loans are that advantageous and think that the coronavirus related distributions are much more preferential for plan participants. So we have had a couple plan sponsors opt to not allow the participant loans for a number of different reasons.
Okay. Moving forward on loan repayment extensions for qualifying individuals with existing loans, repayments due between 3/27/20 and 12/31/20 can be delayed for up to 1 year. Interest, though, will continue to accrue. The loan term can be extended up to 1 year. Loan repayment schedule can be re-amortized to account for the interest accrued during the delay. Record keepers are taking a different approach on this. And then ultimately, Christian, I really have to bring you in here because I'm certain there are some audit considerations.
Yeah, thank you, Bradley. There are. Again, you need to document approval of this increase in the loan if you so choose to do it as a plan. Again, you don't have to. I think I agree with Doug. I think a lot of the TPAs are putting it into the plan docs, and by default you're adopting it unless you specifically decide you don't want to. A couple of things to consider within the loans. Doug mentioned your plan document may not allow for loans, so you may have to amend your plan doc to start with to allow for them. And if you do allow loans currently, you need to consider how many loans you do allow. So say, for example, if your plan doc limits the participant to one loan at a time and they already have one, then they would not be eligible for this option. So you may consider amending to allow additional loans.
Yeah, Christian, let me jump in real quick. I think I've heard some disagreement around record keepers about whether if you only allow one loan and someone wants to take a coronavirus related loan, whether this is a new type of loan or whether it's just another loan that you need to increase your loan limit to 2. I'm sort of in the camp that I think you should make it clear if your current loan policy only allows 1 and you're going to allow these coronavirus related loans, I think you should either increase it to 2 or specifically indicate in an amendment or in a planned loan policy that this is going to be treated as a new type of loan that won't count against the 1 loan. So I think I kind of tend to be more conservative there and say that you need to make sure that your loan policy or document at least allows it, because if your current plan document or loan policy only says 1 loan, but you're going to allow individuals to take more than 1 loan as a result of these coronavirus related distributions, I don't really like that. I think it should be documented somewhere.
Yeah, I agree.
Yeah, totally agree with that, Doug. Great point. And then just a comment or two real quick on loan versus, hardship distribution versus the coronavirus distribution. A hardship distribution is taxable at that point in time, as to where a loan is not, and the coronavirus distribution could end up not being a taxable event if it's paid back. So I think by default, I don't see an increase in need for hardship distributions, especially for those that may need them for relief from being evicted or having their house foreclosed with the HUD's orders of foreclosure stoppages for a period of time. That kind of eliminates the need there for a hardship distribution. But in regards to a loan, read this a couple weeks ago. I thought this was very good. If you have a participant take out a loan under this program, and then they're subsequently terminated or they leave employment, generally speaking, that loan's now going to be in default, because the typical way that gets paid back is through payroll deductions, and if they're not working, obviously there's no payroll there. So now that becomes a taxable event, and they don't have the option to pay it back as they would with a coronavirus distribution. So you may consider that, if an employee comes to you or a participant, make sure they understand the options there and the ramifications of each. And also from a plan perspective, you may consider looking at your payback options and allowing ways to pay a loan back other than through payroll deductions. That way, if the employee separates from service, they can continue paying that loan back through some other means, and therefore wouldn't be a default.
One thing I wanted to add about these, both the hardship distribution, the coronavirus related distribution and the coronavirus loans, and that is plan sponsors, if they are going to allow it, number one, I think that they need to tell participants about it. So we've gotten questions about whether we can just change the plan and allow it, but not tell people about it. I think that kind of runs contrary to, a lot of our thinking. So I think you need to tell participants about it. And then number two, I don't think you need to encourage these things, right? I mean, keeping money, these retirement plans, and again, I know Brad and Christian and others will have comments about this, but they're designed to provide for retirement. And so taking out money now, especially with many of our hope the market will recover or begin to recover, maybe it already has, but continue to recover, taking it out now and is basically a way to seal some losses or solidify some losses that you may not be able to get. So some plan sponsors and a lot of clients that we've been talking with have put a kind of a cautionary sentence or two in certain communications that just remind people that this is meant for retirement. And if you take money out now, you may lose the benefit of a rising market if and when that occurs. So Brad, I don't know if you have any thoughts on that.
I couldn't agree with you more on this. It's obviously an individual by individual kind of exercise that you have to sit with a client and really understand their needs best. And it all boils down to education. So the advisors that are on these plans, the plan sponsors really need to work with each other kind of hand in glove to make sure that they're addressing this education and people understand the impact of taking money out early. That you hit the nail on the head there, Christian. I'm sorry, Doug. But Doug, moving forward, let's talk about, because you brought up pulling money out of a plan, let's talk about required minimum distributions and the waiver for 2020.
Sure. Yeah, and I'm going to move through this quickly. May not touch all of it, but the CARES Act provides that all required minimum distributions, which are required to, these are the distributions that are required to come out of 401k plans, 403bs, 457bs, and IRAs once individuals reach this year and going forward 72, or depending on if the plan allows it, later of 72 or when they separate from service. So the CARES Act provides that there are no distributions in 2020 that are going to be considered required minimum distributions. Or said another way, plans are not required to make RMDs in 2020. So any 2019 RMDs that were paid in 2020 before April 1 are also not considered RMDs. They didn't need to be taken, and so those can be repaid. And this rule applies to everyone. So you don't have to be a qualified individual in order to get the benefit of this rule. This rule is not optional by plan sponsors. It automatically applies. So there are no RMDs in 2020. If a 2020 RMD was already made, and there were some that, some clients that we had that they had already made some 2020 RMDs, those can be restored, rolled back into the plan, or rolled over to an IRA. So they can be, they're essentially treated as a distribution that's eligible for a rollover. So as long as you either as a plan participant either repays it or rolls it into another plan, then there won't be any tax effect to the participant. Now, if the participant keeps it and doesn't either return it or roll it over to another plan, then it would be taxed as a distribution.
Excellent. And Christian, just moving forward, can you touch on next couple of slides, the filing deadlines and extensions?
Yeah, thanks.
Let me jump. Just let me jump in real quick. We're nearing the end. We have about 10 minutes left. So I know we don't have many slides left, but just wanted to let you know that.
Okay, thanks, Diane. Yeah, just real quick, on the filing deadline extension, you can see the dates on there in the bullets. The big point to make here is that for calendar year-end plans, those ending 12/31/19, this slide doesn't impact those plans because your filing date's 7/31, which is past the 7/15 extension that's been granted. So for year-end plans, there's no change there as of yet. So still do 7/31. And then defined benefit plan funding, here you can see where the employer contribution due in 2020 is now not due until 1/1/21. And that includes quarterly contributions. And of course, interest will continue to accrue on those.
Okay. And so let's briefly touch on the CARES Act plan amendments. Again, the CARES Act provision may begin applying immediately as of the Act's 3/27/20 effective date. Plans must be amended to reflect the provisions that the plan sponsor wants to include. The CARES Act plan amendment deadline is the last day of the plan year that begins in 2022. Plan document practitioners, usually plan's third-party administrator, will determine the CARES Act plan amendment defaults that will apply, and employers will be given the ability to override defaults and customize the plan's CARES Act provisions. I know that's a lot, and I'm sure, again, Christian, let's talk about audit considerations here.
Yeah, sure, Bradley. And as one could probably guess, it's documentation, especially related to that fourth bullet. So you're going to have basic defaults items within the plan amendments coming from the TPAs, and plans need to document, as Doug was saying, the fiduciary duty they need to meet. They need to document and decide what they're going to do, whether to override or go with that. But again, it's affecting your plan documents, so it needs to be documented within your plan minutes, board minutes, whatever that oversight group is.
Yeah, that's a good point. So, and Christian mentioning that that the decision on what you're going to do, what a plan sponsor is going to allow or not, needs to be documented. But the plan amendment itself doesn't need to be adopted until the last day of the plan year that begins in 2022. So that's an important point for a couple of reasons. Number one, the IRS is probably going to not only issue regulations, but also issue proposed language for those amendments, like they often do for legally required amendments. So I think there's a good chance the IRS will, I don't know if it's going to happen later this year, but probably next year, adopt or provide model language for plan sponsors to use. So I don't think it really makes a lot of sense to try to come up with language now for actual plan amendments and try to incorporate every single CARES Act provision, because again, the IRS is going to most likely provide model language, and regulations will come out that flesh out how all these things are supposed to work. So if a plan sponsor tries to go in and fully amend a plan now, most likely you're going to have to go back in and change that. We have for a couple clients that were already restating their plans, and again, these were individually designed plans this year. We have indicated where, just in general statements, that the plan sponsor will be, or the plan will be, including the CARES Act provisions related to coronavirus-related distributions, plan loans, et cetera. That's okay to do if you have an individually designed plan to indicate that. I just don't think you need to go in exhaustive detail about how those things are supposed to work.
Very nice. And then, Doug, can you quickly touch on the agency relief? I know there's a lot to unpack here as well, and we have limited time, but I'd love for you to kind of get into this very quickly.
Sure. And just so you know, I think you all probably have seen a lot of resources about, a lot of COVID-19 benefit resources that may be crossing your desk. We do have a longer alert that we published, that Bass, Berry & Sims published last week, that goes into more detail about all of this agency relief regarding timelines for participant notices and other documents, both on the health and welfare and retirement plan. So certainly you can check on that, and there's other law firms and other companies that have released guidance. But this was just in the last couple of weeks. The Department of Labor, IRS, and PBGC have released guidance relaxing the deadlines for certain benefit plan notices and other documents, and providing more time to meet certain operational requirements of administering a benefit plan. Some of those important extensions include the Form 5500 filing deadlines, distribution deadlines for ERISA required participant documents such as SPDs, SARs, blackout notices, SMMs, and other items. The time period has been extended to 60 days after the announcement that the COVID-19 emergency is over. So they're really delayed during what the agency has defined as an outbreak period. And the outbreak period is the length of time beginning on March 1st, 2020, and then ending 60 days after the announcement that the COVID-19 emergency is over. So if you were required to provide any notices or documents that fall within this guidance, and you were first required to do it anytime during that outbreak period, then essentially the period during which you have to provide it won't start until the end of the COVID-19 emergency. So again, very brief. There are a ton of different notices and communications and other things that are affected. Feel free to visit our alert or others' alerts. Or if you have any questions, feel free to send it to any of us on the panel.
So Diane, I know we're kind of at the end here. Do we have any questions that we might want to touch on? And we'll just skip over the last slide, but because I really want to address any questions that we might have outstanding.
Yeah, quickly, just first to say we do have some questions on PPP loan funding and how that relates to all this. So that is kind of outside of this seminar. So we will try, like I said, and answer those outside of this. One question is, it says you've used the term fiduciary several times on this call, but aren't the decisions to add these new provisions were not actually settler decisions? We did not bring these before our investment committee for decision.
Sure. Yeah, so the decision on whether to allow coronavirus-related distributions, plan loans, is a settlor decision. It's not a fiduciary decision. Things don't become fiduciary until you start talking about how a plan is going to be administered. And so that person is correct. The decision on whether to offer these things is a settlor decision. A lot of our clients have delegated certain amendment authority to their retirement plan committee. So that's kind of where it can come into play. But if you're a plan sponsor that hasn't delegated any amendment authority to a retirement plan committee or otherwise, then the decisions about whether to offer these things are settlor decisions. And even if you've delegated it to a retirement plan committee, you've done so, and they're going to be exercising the settlor responsibilities on plan design on whether to adopt these things or not.
Thanks. And then one common theme that kind of came up a few times is there any reason that a company would not want to adopt any of these provisions? Would there be any benefit?
Again, I think the plan loan issue that I mentioned before, a couple plan sponsors have expressed some resistance to wanting to do that. Again, like we spoke about, the issue about plan leakage and amounts, leaving a retirement plan, is another concern that Brad spoke about. Other than that, ESOPs don't typically allow plan loans and hardship distributions. So even though the CARES Act would purportedly allow those plans to offer these things, I think most of our ESOP plan clients will not be allowing plan loans or hardship distribution or the coronavirus related distributions.
Okay, and then one last question, and this came up a couple times too, is say a company changes their compensation structure as far as bonuses or how they're paying or terms. Is there any ramifications of that to any of these regulation changes?
I think the definition of compensation in a 401k plan, and Christian and Diane, you know this too, is one that causes some heartache from an auditor's perspective, a plan operational perspective. So if you're changing up compensation, adding types of compensation or eliminating them, you definitely need to think about what the impact that can have on the definition of compensation that you're using in your 401k plan for both deferrals, for employer contributions, and possibly for testing as well.
Yeah, and you just want to make sure that if you do make any changes, again, you'll need to amend your plan, have that, again, approved and documented just to support anything. So I think that's all that's kind of out there. We do have some other questions, but like I said, relating more to PPP loans. But I want to thank Bradley, Christian, and Doug for the presentation today. And one final note and takeaway, just please make sure to reach out to any of us with any additional questions that you may have to help navigate all these issues that we're dealing with. Again, we are recording this and we will send a link out to all the attendees, so you'll be able to download that, or again, go to our website, www.mjcpa.com, and you'll be able to get that. So We want to thank you for joining us, taking the time out of your day, and hopefully you got some good takeaways from the presentation today. So take care of yourself. Hopefully everybody's cherishing the close time they have now with their family and friends as we navigate through this. And everybody stay safe and have a great day. Thank you, everybody.